Alrighty. Good afternoon, and thank you all for coming. I'm Jonathan Adler, a professor here at the law school and the director of the Center for Business Law and Regulation. Thank you for making time this afternoon to join this conversation with Judge Jeff Sutton on his new book, 51 Imperfect Solutions. It's certainly our pleasure to welcome him to the law school to talk about this important book and its implications. For those that are interested, the bookstore does have the books for sale outside during the reception after the program. If you're interested, you may pick up books there, and I understand the judge may be willing to sign some copies as well. So real quickly, in terms of the order of our program, or what we're going to plan to do today, is Judge Sutton is going, after I introduce our speakers, Judge Sutton is going to speak briefly about his book, the thesis behind it, why he decided to write it, and what we can learn from 51 Imperfect Solutions. Then we're going to have comments from Dean Hill and Dean Steinglass, just to give some additional perspective on the book. We'll then have some conversation up here and then invite your questions about the issues that are raised. As I think you all know, Jeff Sutton is a judge on the U.S. Court of Appeals for the Sixth Circuit, sitting in Columbus. Previously, he served as solicitor of the state for the state of Ohio, as well as a partner at Jones Day. He clerked on the Supreme Court for Justice Lewis Powell and Justice Antonin Scalia, and I think is widely regarded as one of the most prominent federal judges, and one whose opinions are generally worth reading. That's certainly my view, and I look forward to those advanced sheets with his name on them on a regular basis. And most importantly, for our purposes, he is the author of the new book, 51 Imperfect Solutions. Dean Jesse Hill is Associate Dean here in the law school and teaches courses in constitutional law, civil rights, and civil procedure. She will offer some comments on the book, and then we will hear from Dean Stephen Steinglass, who is both professor and dean emeritus at our neighbor down the street, the Cleveland Marshall Law School, as well as most recently the senior policy advisor for the Ohio Constitutional Modernization Commission. And he will offer some comments on the book as well. You didn't come here to listen to me, so without any further ado, I am very pleased to be able to turn the program over to Judge Sutton.
Oh, thank you, Professor Adler. Thank you for coming. You write a book, you learn who your friends are. My family's kicked me out of the house. They don't want to hear about it anymore, so you got an hour with me, and I'm very excited about this. Thank you, Professor Hill, Professor Steinglass, for also engaging with me on the book. I'm going to try to limit myself to 15 minutes to give you a couple points, particularly why I wrote the book. Let them respond, and I think get a conversation going, which eventually will include you. So I'm at an event in Columbus recently, and a retired doctor friend of mine comes up, Dr. Dick Briggs, and Dick says, "Oh, Jeff, I heard you wrote a book. That's so exciting. Is it an autobiography?" And I said, "Oh, not exactly." "Well, then is it a mystery?" I said, "No, not exactly." "Well, Jeff, what's it about?" I said, quite enthusiastically, "State constitutions." Long, awkward pause, and then Dick says, "Sure it's not a mystery?" So my key thing here is to explain why someone would do this, especially a federal judge. And let me give you my whys, talk a little bit about the book, and I'll kind of just cut myself off at 15 minutes, knowing full well that I'll be able to talk later and say some of the other things I might have said. So reason number one, if one were to go to the case library, frankly any law school library in the country, and look for all the books about constitutional law, you would see two big deficits. Virtually all of them would teach just half of the story, which is to say they would focus on the U.S. Supreme Court and the U.S. Constitution, rarely mentioning, if mentioning at all, state courts and state constitutions. By the way, that's the truth in America circa 2018. That would not have been the truth in America in the 19th century. Back then, the books were called American Constitutional Law, and 4/5 of them were about state constitutions and state courts. So something's happened that's changed that, and at a minimum, I thought it was worth writing a book that reminded people there are state courts and there are state constitutions. The other thing you would find about those books is that they generally follow the same narrative. In fact, the narrative is so often followed, it's almost cliche. The narrative goes something like this: good guys, heroes, U.S. Supreme Court; bad guys, villains, state courts, state governors, state legislatures. Now, quite sadly, in American history, there's quite a bit to support that narrative, the most conspicuous example being Jim Crow, leading to the greatest civil rights decision by the U.S. Supreme Court in Brown versus Board of Education. So the last thing I meant to do was set out to contradict that narrative, but I did think it was useful to supplement that narrative with some stories in which the state courts were the leaders, and a couple stories where the GOAT was actually the U.S. Supreme Court, where by the verdict of history, they really got it wrong, and the leaders, the heroes of the story, were the state courts. So that's reason number one. The reason number two, as a federal judge, my convictions about this issue have really grown. It's very strange for a federal judge to write about state constitutions, just to make sure you understand how odd it is. In almost 16 years, I've had one state con law issue in front of me of any significance, and it was one where I was required to follow exactly what the U.S. Supreme Court has done. So this is not something I get regularly. So why would a federal judge care about this? Well, it's really twofold. I had the good fortune of practicing quite a bit in front of the U.S. Supreme Court, and now as a junior varsity Court of Appeals judge, I report to the U.S. Supreme Court. So I've been watching the U.S. Supreme Court for a good 25, 30 years. And I'm very anxious about where it is heading. So I see two options. I see path A, the path we're on, and I'll get to path B in a second. Path A is basically, if you can't beat them, join them. Blue rights here, red rights here, escalating rights. Blue rights, red rights, blue rights, red rights, blue rights, red rights. What that really translates to is the U.S. Supreme Court exercising more and more power over time with critical issues in American government and in American society. In one sense, I should love that story. I'm a federal judge. I can go around saying I'm a federal judge. I can go around talking about all the power we're wielding. And I guess I tend to trust judges more than most people. So in one sense, I should be very happy with how this is working. But as I think we've watched over the last couple of years, if not decades, when you have a branch of government exercising that much power, the stakes get very high when it comes to filling slots in that branch. So one can make the argument that a couple of years ago we elected a president as a proxy for filling one seat on a 9-member court. And I don't think I need to remind you that a lot of people seem to care a lot the last couple months about this most recent vacancy, and seem to care a lot about what are we going to do with the next vacancies. The problem with the escalating rights point is when you keep having these winner-take-all disputes, the American people are not fools. In fact, I actually can justify what happened the last several months. The American people should care about this. The American people should do everything they can to control the court, because that's where the power is. So what's happening is not going away. It's going to get worse, not better, and in my view is likely to end in tears. But there is path B. So path B is some kind of a détente where the U.S. Supreme Court stops recognizing and nationalizing all these issues and stops being in the business of winner-take-all rights dispute resolution. Path B is quite optimistic and maybe naive in this sense. We Americans love judicially enforceable rights. I doubt there has been a country in world history that cares more deeply or prizes more judicially enforceable rights. I don't see a way of changing that. Personally, as a matter of my own conviction, I would rather see us focus more on legislatively protected rights than putting all of our eggs in the judicially enforceable basket. To be very concrete about it, if I had to pick the 1964 Civil Rights Act or Brown versus Board of Education, I could only have one, I would always take the 64 Civil Rights Act. Why? Way better to live in a country where the culture, the policy culture, the legal culture is a majority of Americans looked after the minority and the dissenters, rather than a culture where we rely on 5 members of a 9-member court to protect our rights. So personally, as a matter of my own conviction, I prefer legislatively protected rights, but I think it's kind of delusional in America circa 2018 to think that's going to only be our source of rights protection. So rather than swim against this stream of judicially enforceable rights, of a strong preference for them, I'd rather swim with it and that gets you to state courts and state constitutions. If we're really going to have a détente of winner-take-all rights disputes resolutions at the U.S. Supreme Court, the only way to do this is for people to feel confident and comfortable that their state courts will take those state constitutions seriously, and when appropriate, recognize rights, whether they're rights customized to Ohioans or maybe rights customized to regions of the country. But that's really the only way we'll ever get off this path. So that's my motivation. So what exactly do I mean by my argument, and how can I say so quickly that if you don't win at the U.S. Supreme Court, you can win at the state courts? Well, one of the ironies about the fact that we Americans put so much trust and faith in the U.S. Supreme Court and the U.S. Constitution is that not a single one of those guarantees that we care so deeply about originated there. The greatest era in Constitution writing in this country, indeed, according to Gordon Wood, world history, is between 1776, declare independence, up to and before the summer of 1787. In other words, before the fabled summer in Philadelphia. Philadelphia, the only innovation of the U.S. Constitution when it comes to rights protection is federalism, splitting the atom of sovereignty. But the rights guarantees that eventually show up in the first 8 provisions of the Bill of Rights and the 14th Amendment, those all come from state constitutions. So point number one is the state constitutions are the original source of these rights. They used to be taken very seriously, and they're taken less seriously today, and maybe that's worth correcting. The second point is basically a math point. 2 is usually better than 1, unless the 2 are things you don't like. But if the 2 are things you like, free speech rights, equal protection rights, due process rights, protections from unreasonable searches and seizures, which we Americans like, you're always better off having 2 arrows in your quiver rather than 1, or if we want to use a basketball analogy, take both shots with the two-shot foul. Why wouldn't you do that? So let's be more concrete about that. Last term at the U.S. Supreme Court, there was a very significant case called Gill versus Whitford. It's about extreme partisan gerrymandering. The goal of the plaintiffs, principally from Wisconsin, I think maybe one of the cases was Maryland, was to identify a 14th Amendment right that prohibited extreme partisan gerrymandering. Now, the court was not willing to accept that. They didn't go down that road. They didn't say the opposite, but so far, they're not constitutionalizing the issue. I don't care how little one trusts state courts. I don't care how little you care about state constitutions. You can't win under the U.S. Constitution right now. We don't know what's going to happen with the new court, with Justice Kavanaugh, but for right now, you can't win. There is no such right at the U.S. Constitution and at the U.S. Supreme Court. You have just one option at this point. State courts, state constitutions, or other state avenues. As we know in Ohio, we have an initiative that's trying to come to grips with this. The Pennsylvania Supreme Court addressed this issue last March under its own constitution. But I don't care how little you care for state courts or state constitutions. When you have lost at the U.S. Supreme Court, unless you really like losing, the only choice is to go to state court and use state constitutions. And let's face it, half the time you lose. I mean, that's the way this works. You don't always win. And so to me, that's really the key kind of theoretical explanation why you need to start taking this more seriously. It's not just, however, that you have a second shot. It's quite often the case that the second shot is a better shot. Now, state courts are going to vary around the country. Some are going to be more progressive about this issue, some more progressive about this issue, some like blue rights, some like red rights. But the fact is, the state constitutions, while they protect many of the same guarantees as the U.S. Constitution, often are written in ways that require different interpretations, demand different interpretations, and often interpretations that can be customized to local values, local history, local policy concerns. A great way of illustrating this is think of these 3 states and the free exercise of religion. Utah, Maryland, and Rhode Island are 3 states that were founded by religious dissenters. All 3 states protect free exercise of religion, if not more. Some of them protect the right to conscience. Surely, in light of the history of those 3 states, the state courts in those 3 states are going to be more sensitive to the position of a religious dissenter than a state without that history. The U.S. Supreme Court can't premise a decision about the free exercise clause, or for that matter, any other guarantee in the U.S. Constitution, based on the local history of a couple states, one state. They're stuck with doing something for the whole country at once. And unless there's some history that's specific to that guarantee at the U.S. level, they're not going to be able to customize it in the way a state court can, or in the way a bunch of regional state courts might. The other reason why your shot may be a better shot is we live in a world, I'm going to be a little reductionist here, but we live in a world where there are basically two types of interpretation. There's the fixed, it's written, it means what it meant when it was written, and it doesn't change over time. Think of a contract. Contracts don't evolve over time. Whatever they meant at the time they were written, they mean today. That's the originalist, Scalia-Thomas school of thought. And the rest of it is a school of thought that says, well, the words are so general, it's so hard to figure out what they originally meant, that we have a right to either account for shifting norms in society, see Obergefell, the same-sex marriage case, or the right to account for pragmatic explanations for perhaps innovating a new right. That's all there is. There's really just two types of interpretation. When the U.S. Supreme Court adopts an originalist, more formal interpretation, and you have a state court where a majority of them are pragmatists or living constitutionalists, how is it that they would agree with the U.S. Supreme Court in construing similar language? All of our constitutions have due process clauses. Why would a more pragmatic, more flexible state court agree with a more formal, originalist U.S. Supreme Court decision? There's no reason in the world. Half the time you're going to have that disparity. Half the time you're going to have a situation where the U.S. Supreme Court is motivated or dominated by an originalist or a non-originalist perspective, and you're going to have a state court that's the opposite. Every single one of those cases should be a case where the state court does not follow the U.S. Supreme Court, or at a minimum doesn't reflexively follow it. The last point, and this will lead to my two last points really, and then I'll turn over the microphone, is the guarantees that we care the most about, whether in the state or U.S. constitutions, are written in the most general terms. And yet we in America think whatever the U.S. Supreme Court says is the only way of construing that language. It's really a strange way to think about it. Due process, the phrase unreasonable searches and seizures. Unreasonableness demands different interpretations to account for different approaches to a privacy versus government particular problem. So it's just very odd that instead of 51 different approaches to construing due process, free speech, unreasonable search and seizures, we seem so inclined toward this presumption whatever the U.S. Supreme Court does must be right, not just for federal law, but for all 51 constitutions. It's really strange. I'm going to try to illustrate how strange that is by referring to something. This will be my last point. So Justice Brandeis, one of the great justices in American legal history, had an insight that I'm pretty confident if I could get every citizen in the Case Western community, indeed the whole Cleveland bar, think of this, in our day and age, I could get agreement from that many people on one thing. I really think I could do this, and you challenge me if you think I'm wrong. Justice Brandeis said, there's one unalterable, unimpeachable virtue of federalism, and that is that the states can be laboratories of experimentation in dealing with new policy problems facing society. What Brandeis was referring to is policy-making experimentation, and he was referring to state legislatures as the bodies of experimentation, the labs of experimentation. Now, we might disagree about what areas to have states as labs. I don't think anyone disagrees that the model of federalism of using states as labs in terms of policy experimentation is a pretty good idea. Why have an experiment for 320 million people before trying it out? That's really high stakes, high risk. So most people think, I'd say everybody thinks Brandeis was right. I'm taking the Brandeis idea, this is the whole point of the book, and saying, why are we not doing the same thing with labs of constitutional interpretation? Why wouldn't we take exactly the same approach? Due process could mean a lot of different things. Search and seizure in an age when the government has access to all of this technology, or access to our technology, why would we not try lots of different approaches to unreasonable searches and seizures rather than this obsessive focus on the winner-take-all? Winner-take-all is wonderful, but I'm telling you, you're not going to win every winner-take-all fight. And the only people that should like winner take all are the people that can honestly say, I'm happy with winning half and I'm happy with losing half. And just remember, when you lose that half, that means you have no voice on that other half. And if you're honestly willing to say that, you are for winner take all. But I've just not run into too many people that think that way. They love the victories and they think the losses are evil. So I'm not for that. I'm for, let's try a little more experimentation, a little more patience before we do the winner take all. And then, as Brandeis would suggest, you nationalize when nationalization is justified. So thank you.
Thank you, Judge Sutton. Our first commentator will be Dean Hill.
Thank you, and thanks to Professor Adler and Judge Sutton for the opportunity to talk about this wonderful book, which I want to say it really is a wonderful book. I enjoyed it very much. I highly recommend it. I learned a tremendous amount from reading it. There's a lot of history in there, and a lot of it was new even to me as a constitutional law professor, which I think is part of the point of the book, is that the role of state courts in our constitutional history has been relatively unknown and should be better known. So I don't have a whole lot that I want to I sort of don't want to disagree with the central premise of the book. I find it very appealing. I'm sympathetic to it and to the central premise of Judge Sutton's remarks. I maybe have a few quibbles here and there, but I do think that the argument is very persuasive, and I do think it's one that we can subscribe to regardless of our sort of pre-existing ideological approaches or views about constitutional law, as well as regardless of our approaches to constitutional interpretation. I want to start with something which is where Judge Sutton raised kind of early on in the book, which was this question, and also some in his remarks, about why do litigants not foreground state constitutional claims more? And so I want to give a few thoughts about that, and then if I don't want to talk too long either, so maybe I'll see if I have time to say something else. Okay, so as somebody who actually, I not only teaches constitutional law, but I also litigate constitutional law cases, although I can't claim to have the deep knowledge of state constitutions and state constitutional law that I think my other two co-panelists have. One thing is, I think that the reality is that choosing to press state constitutional claims often means choosing state court as a forum for those claims, and that's not 100% true. But by and large, you can't litigate your state law claims against the state constitutional claims against the state in federal court. The picture's a little more complicated than that, but that's essentially the case. Now, if you're a criminal defendant who's being prosecuted in state court, you don't have many choices about your forum, right? So I think it does make sense to say, raise state claims, constitutional claims, raise federal constitutional claims, maybe foreground the state claims if you think you have a chance of winning them. But if you're bringing a case affirmatively as a plaintiff, a constitutional challenge to a state action, you basically are saying you have to forego a federal forum for your claims in order to foreground state constitutional claims. So you could bring your federal claims in state court, but you can't win or bring your state claims in federal court. So I think that's, and in some cases that can be really troubling. I mean, sure, if it's settled that you're going to lose your federal claims under the federal constitution, then maybe you have nothing to lose with choosing state court as a forum. But if it's less clear than that, it can be, depending on your state, a bad idea to borderline malpractice, I think, to entrust your claims to state court judges. Particularly, I think in some states where judges are elected, the chances of winning a claim with certain kinds of litigants in certain kinds of cases can be very, very low. And I think that's something else that's maybe just worth pointing out, and we could talk about it a little bit more. But a lot of the states that have a well-known and sort of proud tradition of independent constitutional interpretation are states where the Supreme Court justices are not elected. So Iowa, for example, New Jersey, Massachusetts. There's also, I think, another reason to why that's maybe a small reason, maybe it's why you don't see constitutional claims brought as much in a state forum, which is that under federal law, if you are bringing a lawsuit to vindicate federal constitutional claims, you get the advantage as a plaintiff or as a plaintiff's attorney of 42 U.S.C. Section 1988, which allows you to seek attorney's fees if you win after the case. And of course, the whole point of the provision is to encourage plaintiffs, private plaintiffs, to bring these lawsuits to vindicate constitutional rights, especially considering that most plaintiffs are not going to have the resources to pay an attorney hourly to bring a suit. And if there's no damages, if this is an injunction suit, they may not be able to make any sort of contingent fee arrangement either. So, but in many states, there is not an equivalent of Section 1988. So I don't believe in Ohio, for example, that you can get attorney's fees if you successfully win under the Ohio State Constitution, an Ohio State court. So I do wonder if that might actually be maybe a friendly amendment or a friendly suggestion of ways to encourage state foregrounding of state constitutional claims would be for the legislature to adopt an equivalent of 1988 for state constitutional claims. I'll say one more thing quickly. Maybe I'll just raise it and then I'll stop because I certainly don't want to talk longer than Judge Sutton has spoken. One other question is just is sort of why centers around the question of why might state courts go in a different direction. And maybe it's a better topic for the Q&A, but initially, I had understood Judge Sutton to take the view that state courts should only deviate from federal constitutional interpretations when there was some basis either in the original meaning of their constitution or maybe some sort of unique local concerns that would cause them to deviate, but that really states shouldn't just decide that the federal courts were wrong and that they wanted to come out differently. And I'm not sure, I didn't hear that as much in the judge's remarks, so maybe I sort of overread that point of view, but I would like to sort of think about that a little bit more because there have been cases in which state courts go in a different direction, not so much, again, not because their constitutions come from a different place or because their local policy issues are so different from those that might have been motivating the U.S. Supreme Court or the federal courts in another area, but simply because they say, the Supreme Court just came out wrong on this one. And so maybe we can come back to that question of whether that's a legitimate move or not by state courts. But I will stop there. Thank you.
Well, thank you. Dean Steinglass.
And I will begin, also try to be relatively brief. First of all, Jeff has really written a fantastic book. It's well written, well researched, the kind of book you can give to your high school senior and he or she will be able to understand it. But for those of us who are a little nerdier, it's full of footnotes and you can track the footnotes and it's really nicely done. What Jeff has is a basic thesis that if state constitutions were taken seriously, it would benefit American constitutional law, both state and federal. And I clearly recognized how an individual litigant would want a second bite at the apple. Systemically, however, I tend to agree intuitively that both systems are better if you have a viable state constitutional doctrine. But really, that's an empirical question. And how do you prove it? Well, Jeff can't prove it, but Jeff then tells us some stories. And each of the stories to which he alluded, but they're really worth looking at. He tells the story of school funding, the Duralf case in Ohio. He tells the story of eugenics, Buck versus Bell, 3 generations of imbeciles are enough, one of Justice Holmes' least memorable, maybe memorable, but least positive comments. He tells the story of the flag salute cases, Barnett. And he tells the story of Mapp versus Ohio, aftermath, the development of a good faith exception to the exclusionary rule. In each of those areas, he identifies with footnotes, careful footnotes, the role that the states played. And we find, as he suggested, we find that the United States Supreme Court failed badly in the eugenics cases and in the school salute cases, at least initially. In the school funding and school prayer, they failed at least initially. In the school funding case, I think it's fair to say they abdicated the so-called federalism discount, and they left the work to the state courts, and the state courts have been very, very active. And then in the final area, it's still chapters still need to be written about the exclusionary rule. In addition to that part of the book, he concludes with suggestions for judges, lawyers, and law schools. I'm going to not say anything about that. His book is incredibly timely as we sit on the verge of what may be a major retrenchment of the Supreme Court and the lower federal courts. A strong body of state constitutional law may be even more important. The irony, though, is that the message is not unique. The messenger may be unique. It's not often that a member of the federal judiciary weighs in on state constitutional law, but Judge Sutton has done so and done so repeatedly. But the message is not new, and in many ways it follows the lead of one of the Supreme Court's greatest justices, William J. Brennan, who noted favorably more than 40 years ago that state courts had begun to pay more attention to their own constitutions, a development he attributed, at least in part, to the direction in which the Supreme Court had been moving. Judge Sutton pays homage to Judge Brennan, but criticizes his approach as being too result-oriented. Leaving aside the validity of that critique, it is clear that Justice Brennan played an important role in popularizing resort to state constitutions. Indeed, along with such prominent state court judges like Hans Linde of Oregon, who's been called the intellectual godfather of the state constitutional law movement, they spawned what might be seen as a cottage industry. However, compared to the palace built by the U.S. Supreme Court, it's a modest cottage. Jeff has taken us to the starting line. He has told us that a robust state constitution is a good thing for American constitutional law. But he's judicious, as I suppose he should be, about what the new modern state constitutional law would look like. So I won't say anything about that. I'll be judicious as well. But I will say that he spends a good deal of time, and he hasn't said anything about it today, about something called the lockstepping approach. Lockstepping, it's not marching. It has to do with construing constitutions. And under the lockstep approach, state courts defer to federal courts, the U.S. Supreme Court, when they have identically or similarly worded constitutional provisions. Judge Sutton demolishes the lockstep approach. He basically sees it as an abdication of state courts' responsibility to try to understand their own constitution, its text, its history, state conditions that may have led to it. And I think that is a major contribution. The approach he prefers, the primacy approach, however, has not been widely adopted. 3 or 5 states, depending how you count, have embraced it. The primacy approach is not looking to what the U.S. Supreme Court did and saying, why should we deviate? That is a variant of lockstepping. The primacy approach is, let's look at the state constitution and look at it afresh and see what is it about the text, the state constitutional convention, the state history, the state traditions, precedent, what the newspaper said, whatever the tools are, what is it unique, what is it about that provision? And then, and only then, go and read the precedents on the U.S. constitutional decisions and make a decision, ideally both. And so we're left in the middle. We're left in the middle, and that's, I think, what lawyers and judges are going to have to struggle with as they approach state constitutions in this era. It seems to me that state constitutions have been used far more often than Judge Sutton's comments suggest. As Jesse said, you got to look at the litigant. The litigant sort of takes their predicament as they find it. If you're a criminal defendant, you don't have a choice of forum. You're stuck, and you have every incentive in the world to try to get as many bites at the apple as you possibly can. But if you're a civil litigant, and I would submit that sophisticated civil litigants have for many years looked at state and federal courts, state and federal law, state and federal constitutional law, and made choice of forum and choice of law decisions accordingly. Now, that doesn't mean that there has been an upsurge in academic interest in state constitutions. I will note proudly that the Ohio State Bar Association, a week from today, is going to have its, as far as I can tell, first ever full-day CLE program devoted to state constitutional law. Jeff is one of the keynote speakers at that. So I think we're getting to the point where more respect will be afforded. Final point. If one looks at Ohio, where most of us probably live and practice, you'll see that the Ohio Supreme Court indeed has been addressing and struggling with the question of what is the proper way to construe our Constitution. It's not so much lockstepping versus primary. That really is not what occupies them. It's what do we consider? How important is text? How important is text when the state constitutional provision is identical or nearly identical to the federal? Is equal protection of the law the same as equal protection and benefit? That's what the Ohio Constitution provides, equal protection and benefit. You can find distinctions in language. What does it mean to harmonize Article 1, Section 14, Ohio's prohibition against unreasonable search and seizures, with the Fourth Amendment? What is harmony? What does harmonizing mean? What does it mean when the court says that the state and federal equal protections or due process are functionally equivalent? Functionally equivalent is not identical. What does all that mean? And I think all of those issues are up in the air, and stay tuned. Thank you.
All right, before we go to questions, I wanted to give Judge Sutton a chance to respond to the comments, maybe elaborate on points that he already raised.
Yeah, no, they're really great comments. So I want to start with Professor Hill's point because it's just so critical. Most lawyers do not instinctively trust state courts as a place for individual rights protection. So I've got to come to grips with that, and we have to think through that. Well, first of all, the stakes are really high. The last time you had numbers I think it's 2016, there were 84 million cases filed in state court. That year in federal court, it was 320,000. All right, so there's no such thing as not paying attention to state courts and either federal or state constitutional rights. That's what's going on. So in those 84 million cases in state court, you're an absolute fool not to bring both claims, assuming there's not some other strategic reason. So that's where we are already. Why would you not do that? So, second point, basically half the cases are criminal cases. And Professor Hill's right. I mean, that is the area where the second shot always needs to be taken. There's a case, Utah versus Strieff at the U.S. Supreme Court. Strieff won 5-0 in the Utah Supreme Court. That's a pretty conservative, moderate to conservative court. 5-0, decision written by Tom Lee. Strieff lawyer didn't bring a state constitutional claim. They would have won that argument. the federal decision gets reversed at the U.S. Supreme Court. Edward Streif is in jail because the lawyer's not taking the second shot. I mean, this is really substantial. I mean, this really proves the education deficit on state constitutions. Even before the book and all this talk, 84 million cases in state court. Those are already there. So that's where it seems most obvious. Professor Hill's quite right that when you're challenging a state law, if you're challenging a city law, an city ordinance, these issues don't apply. You can go to federal court and bring the state and federal claim. That was the one where I had both. But if you're challenging a state law in light of Pennhurst, it's a lot more complicated to bring your state constitutional claim in federal court. And so I think she's right. If there's a good reason to be in federal court, and it's just that's your best chance of winning, I think it probably is the right thing to do, and that really is a complication. Of course, you don't have that problem if you go to state court. In state court, you can bring federal and state claims all the time. But I really think we're getting down to a pretty small group of cases at that point where it doesn't make sense to bring both claims. Why did I get involved in this whole area of the law? If you're lawyers or in your law school, I was trained the same way you were. I read the same books about not trusting state courts. Now, perhaps this says something about me and my lawyering ability, but I could teach a whole class about state constitutional law based exclusively on cases I lost at the Ohio Supreme Court under the Ohio Constitution. I mean, my first $35 billion loss was there, school funding, I lost vouchers, I lost tort reform, and I lost criminal cases. Robinette, the Robinette revisited case. And everyone thinks you can't trust elected judges on the criminal cases. So, again, maybe this is Sutton's a bad lawyer exception to the rule, but I saw firsthand that state courts can be trusted to do progressive things. So I think it's a complicated point. I do think there are days where you just take one shot in federal court. I do agree with Professor Hill on that, but that has to be a state law, and it has to be because the federal court really is a better forum. And I think it's getting harder and harder to predict what the better forum is. I'm not a fool. I wouldn't have said in 1945, go to the Alabama Supreme Court with your desegregation case. That's not the point I'm making. What I'm saying is it's 2018, and a lot of these courts look a lot different from how they looked back then. I mean, I'll take a good example from the South. The Georgia Supreme Court has really terrific judges on it right now. That's a terrific court. The California Supreme Court, if there's a Democratic president within the next 6 years, say, 3 people from that 7-member court will be on the short list for the U.S. Supreme Court. Now, if they're smart, they'll say, no, I'd rather stay in the California Supreme Court. But 3 out of 7 will be conservative. I mean, that is a really terrific court. So the idea that either state court judges can't be trusted to do counter-majoritarian things, they're not smart enough. I feel there's evidence for that in the past. I'm not going to deny it. But I'm also saying we're entering a new world, and I think we should be a little more hopeful, a little more strategic, and after all, if you do lose at the U.S. Supreme Court, you have no choice anyway. You've got to try something else. Responding to Professor Steinglass, I mean, Justice Brennan is really a person who really did some leadership in this area, but I want to emphasize, you know, let's say he's the best progressive justice at the U.S. Supreme Court the last 70 years, probably the most prominent conservative justice the last 70 years would be Justice Scalia. His last majority opinion, Kansas versus Carr, he makes the exact same point Brennan was making, the exact same point I'm making. When Justice Brennan and Justice Scalia agree on something, that is truth, and you should just take it and run with it. So it's Brennan and Scalia. It's not just Brennan, and it's a neutral principle, which I hate to break it to you, means you're going to like it sometimes and not like it other times, but it also is a neutral principle that may take a little of the pressure off of the U.S. Supreme Court, which, if we want that institution to survive, might be worth thinking about.
Alrighty, so we're going to have some time for questions really quickly. I just wanted to make a couple quick announcements. First, when this program concludes, we will have a reception in the Rotunda. The bookstore will have books available for purchase. Then also, for those that might be interested, on Friday, November 2nd, the LEAT Symposium, which is also the Law Review Symposium this year, is on fiduciary duty, corporate goals, and shareholder activism. That will be featuring a keynote address by Hester Pierce of the Securities and Exchange Commission. Information about that is on the website, and I believe 4 and 3/4 hours of CLE credit will be available for that program as well. So that's November 2nd. For questions, there will be a microphone coming around. Be sure to wait for the microphone so that it can be caught on video. I will take the moderator's prerogative to ask the first question, and that is, Judge, it seems there's two possible stories to tell about the role of state courts here. One is a discovery story, and one is a diversity story. So the discovery story is if you have 51 cooks trying to figure out the right recipe, the likelihood of one of them getting it right that we can all learn from is higher. And whereas if we only have one set of cooks in the Supreme Court, you get Buck versus Bell, and it's a mess, right? So that's one possible story, that this is a way of letting better ideas percolate up. The other story would be one of diversity, that maybe we're not trying to move towards one answer. Maybe we actually want a system in which there are places where blue rights are protected and red rights aren't, and places where red rights are protected and blue rights aren't, and that's okay. It seems at certain points those two stories are in tension, and I didn't know if you wanted to pick one or if you wanted to.
The second one's the harder one, so I'll
Sure.
deal with the harder one. Yeah, if you have 51 cooks, even if they're all me, somebody's going to stumble upon something worth eating, or get very hungry and then want to eat what isn't worth eating. But the second one is the key one, because that really cuts to this. This is part of our American notion of what's right and what law is about, that there are these fundamental, non-compromisable guarantees of being an American citizen. And, that's where the Brown story is just so powerful, that there's just some things we don't discuss, in the sense of we don't vote about them. It's offensive to vote about them. They're just off the table, and it's not just that that's an important part of our story as a country. It's a pretty successful part of our story, right? I mean, race has been a big problem in American history, and the U.S. Supreme Court, which actually contributed to the problem with Dred Scott and Plessy, really helps us out with Brown. And so I think that's a good story. The thing I fear that we're running into is a little bit of everybody deserves their Brown. Every particular thing that you care deeply about is something that you should get nationalized. That truth should be not something we vote about. That too is not something it's negotiable. And that's what leads to the evolving, escalating rights problem. And so fundamentally, the hard thing for me to say, because it's just very hard for people to accept or agree to, is that I am saying at least one of two things has to be true in the future for this to work. We either have to be a little more patient as a country before we nationalize, which is very hard because that means suffering in the interim, or we have some occasions where we tolerate regional differences about rights recognition. Another way to put that last point, which I would urge you as a way to think about it, why is it that when is it appropriate that Ohioans have a right to tell Montanans what rights matter? And if we think there are times where we Ohioans have a right, where our position is, we feel with such deep conviction it ought to be nationalized, that Montanans ought to do what we think is right, even though only a minority in Montana support it, when we identify those and we think that's right and it's really appropriate, let us also remember there's going to be times where there'll be a majority of Montanans that want to tell us what to do. And if we're willing to accept that, that's okay. But I just think things have gotten more complicated in a lot of these areas, and that a little more tolerance, or at least patience, for regional disparity, for different solutions to emerge, and then ultimately decide, is this something we need to nationalize, or is this something where we can tolerate regional differences? There's very little notion right now in public policy, whether we're talking courts or legislatures, about the tolerance of regional differences. That's just not part of where we are right now. It's winner take all. And I think the interest groups really feed this. If you're an interest group, why wouldn't you want one-stop shopping at the U.S. Supreme Court? Particularly if a victory means you can stop the legislative democratic process on the issue. I mean, that's one heck of a victory. So who wouldn't want it? And that's the direction. But Jonathan, you're quite right. Those are the two things I have to account for. They're the two things people are going to be most uncomfortable with. Yeah, what can I say? I think that's a fair inference from what I'm saying.
All right, questions. So we'll start with Professor N.
I apologize. Amy just told me that the mics are missing.
Oh, speak loudly.
So I will repeat the questions just for the benefit.
There are important differences between the federal constitution and the state constitution.
Yes.
I have not had a chance to read the book, and I'm not going to try to anticipate how you develop this. But even with respect to, say, the rights protecting provisions in the federal and state constitution, many state constitutions are newer than the federal constitution, which might make it easier in some instances, perhaps, than in others, to tell what the framers might have had in mind. How much of a difference do you think that might make to the use and reliance on state law theories?
Yeah, so there's not quite as much out there research-wise on the history of the state constitutions. There's plenty. I mean, Ohio has plenty. There's plenty there, but it's not like the U.S., so you have to go looking. You do have some state constitutions where it seems pretty clear they were adopting almost exclusively the language of the federal guarantees. It's probably fair to assume they meant the interpretation of those guarantees at that point in time. That tells you nothing about the future, but it tells you something about where they were at that point. But you have other histories which are dramatically the other direction. So, as with Ohio, most states were originally territories after the original colonies, and the territorial experience is fascinating. So the one I looked at most recently is Montana. They had a 20-year experience as a territory before they became a state. Guess why they were so eager to become a state? They had territorial courts and territorial governors. Two things there. The President of the United States picks the territorial judges and the territorial governor, and they only applied federal law. Montanans didn't like that. They didn't want carpetbaggers. They didn't want these Harvard-educated friends of whomever the president was. They wanted people from their neck of the woods that understood their culture, their history, whatever it was. So one of the things that accelerated statehood for many territories was being able to pick their own judges and governors, and then, of course, create their own state constitution. So that's a story that cuts dramatically the other direction, which, when you look at why so many state constitutions have guarantees that vary, you'll see that there. I mean, so, the woman's right to vote, that's a story that starts in the western states. They're the ones that innovated that. That is not a East Coast story, and that's not a federal story. That the innovation is all in the state, it's all in the western states. Kind of an ugly story as to why, but so be it. That's what they did.
No questions. You're right here.
Judge, can you give us some examples of constitutional rights that you'd be comfortable with being regionalized?
Yeah, so let me give you an example of a progressive U.S. A decision by the U.S. Supreme Court that progressives would not like. I could do this story from the other direction, but I'll do a progressive one because this gets to a big misperception about this issue. So metaphors can kill, and one of the worst metaphors in con law is that the U.S. Constitution sets a floor that no one can go below. Dead wrong. No state court can go below that. When they have a federal claim in front of them, they have to follow the U.S. Supreme Court and respect their decisions. But if they have a state claim, they can go below the floor, they can go into the basement, they can do whatever they want if we're going to stick with that goofy metaphor. So Citizens United is a case that progressives don't care for. It's probably number one on the list of decisions progressives would like to see overruled at the U.S. Supreme Court. A year after that case was decided by the U.S. Supreme Court, and it's about an 05-06 decision, Montana had a challenge to a corporate funding piece of legislation, was limiting corporate contributions to candidates and parties and so forth. The Montana Supreme Court wrote this long opinion about, well, whatever Citizens United means, whatever the U.S. Supreme Court thinks about the federal free speech clause, that interpretation can't apply in Montana. And the reason they took the view it can't apply in Montana is because they had this terrible history where the copper barons completely controlled the legislature and did a lot of terrible things, including disfiguring the land of Montana. So they write this decision, which shows a complete ignorance of the Supremacy Clause. They're not allowed to do this, and it's because of this metaphor. What should they have done, which is an example of a disagreement point, and this is exactly what my labs of constitutional interpretation is about, is they are allowed to disagree with Citizens United. They have an independent duty to do that just under their state constitution. They should have had a 1 or 2 sentence analysis under federal law, and then they should have said, but there are 2 free speech clauses that govern Montana and local regulations that affect speech. And then gone on and explained why, as a matter of original meaning, pragmatism, living constitutionalism, if they did a great job, they'd win on all 3. They'd show why all 3 are correct. Then they would have had a data point that shows disagreement with the U.S. Supreme Court on a very sensitive topic that a lot of people care about. They wouldn't have looked like fools. I mean, that was a fool's errand to just disagree with the meaning of the federal Constitution. They were reverse 9-0. That was what should have happened. If they had done that 10 years ago, we'd probably have 15 to 20 state Supreme Court decisions construing their free speech clauses and saying, here's what the original meaning is. Here's what the pragmatic reading is. Here's what the living constitutionalist meaning is. So my first point is not to make what I think is the key mistake we've all been making in this area, is that you can only disagree going up. No, you can disagree going down. You can say you should never have constitutionalized this issue. And that would be very healthy if we believed in a free market of constitutional interpretation rather than having one body have a corner on this market. So that one seems easy. So I'll give you another 2 quick ones. Gill versus Whitford, the extreme partisan gerrymandering. There's a case where the U.S. Supreme Court has stayed on the sidelines. Whether it's state courts construing state constitutions, state initiatives, doesn't matter. Those would all work. And then a criminal one would be Carpenter, the case with the cell phone data sites, which monitor where you are if you're carrying an active cell phone. Carpenter nationalized that issue, but very much in part. It's a very humble decision in terms of deciding what the Fourth Amendment means with this new technology. That leaves so much room for innovation at the state level. And to me, the word unreasonable is a great example of something that does allow, this is the final point, regional disparities. I don't have a problem with the people of California or the whole West Coast for that matter having a little more protection or a little less protection than Ohio. I don't know why. How can I say in this incredibly difficult area there's only one way to think about it? It seems to me incredibly arrogant and probably will eventually be proved wrong. There's a long answer, but it's a great question.
I very much hear echoes of what you said in terms of tolerance of the courts, and in terms of let's wait to see what these different courts in different states can do, and I hear echoes of this a bit in what Justice Kennedy wrote in his majority opinion masterpiece Case Shop, when he says that the outcome of these cases, I'm quoting here, in other circumstances must await further elaboration in the courts, all in the context of recognizing that these disputes must be resolved with tolerance, without undue disrespect to sincere religious beliefs, and without subjecting gay persons to indignities when they seek goods and services in an open market. So I understand that partly to mean that Justice Kennedy correctly understand the importance, it was balancing the judicial restraint, right, the idea that we, the judges, are not legislators, with the idea that you have 2 different groups that you have, whose rights you need to respect, right? And that you need to be very sensitive, and maybe we need to hear more of this. And I think in the context of this example, your book comes perfectly. Let the states, let that state arguments, flesh things out. In your answer to the previous gentleman's brilliant question, it's very short, much better than mine. You gave a couple of examples, and they all dealt with separate, independent questions that are solely determined on the basis of in the question, in questions like Masterpiece Cake Shop, where you have these two, groups, religious rights and sexual orientation rights, right? Where questions are not really separate and independent, how much tolerance or how much divergence
Yeah.
do you think the U.S. Constitution tolerates?
Well, I love that case, and I'd love it even more if I don't have to decide it, because it's so hard. But it illustrates American constitutional law circa 2018. What's so fascinating about that case is it's basically a framing question about the two greatest civil liberty cases in the U.S. Supreme Court. So I've already mentioned one, Brown, and the other is Barnett, the Jehovah's Witnesses compelled flag salute case. The whole debate in that case is which one wins, right? Because you could say from a gay individual's perspective, this is a Brown case, discrete, insular minority, being discriminated against, we need the courts to protect them. But from the baker's perspective, if you put the baking and think of it as speech, just except for the second in speech, it looks like a Barnett case, forcing someone to say something they don't believe. And so that just proves it's really hard, and I think what Kennedy was doing was saying we basically need a little more percolation to sort this out. But I'll kind of illustrate another way of coming back to the tolerance point is I'll ask the question this way, which is, it's the rabbi, you respond to a hard question with a question. So I'm going to put the question to you. If you're a progressive, find a conservative friend. If you don't have one, get one. If you're a conservative, you don't have a progressive friend, get one. Sit down. Ideally, this should be lawyers. Let the progressives say the constitutional conservative cases they hate the most. So maybe the progressive puts Citizens United, Heller, but it's a list of 5. Those are constitutional decisions. They're taking it out of the democratic process, and we'll call them red-right type cases. Then, you do the other objective in the same direction. So maybe they pick Roe or God knows what the conservative picks, but it's 5. It's 5 rulings that constitutionalize, and it's even, because they're the 5 ones that help conservatives, red rights, 5 that help liberals, blue rights. Would you trade? Would you take all 10 off the table? Would you say we're going to get rid of all 10 decisions? Democracy is going to fix all 10 of those issues? In other words, you can't just get yours. You've got to pay. It's got to hurt. So what happens? Well, when I raise this with people, people say, I'm not taking that trade. I'm not doing that. So why do they do that? Because it seems like it should be neutral. And it also seems like you should have the courage of your convictions. You should say, well, I think we're on the right side. We'll win this democratically. And after all, we won't have Citizens United. It might help us win a little here or there. And we'll have some other arguments as to why we might win. Most people don't want to take that trade, and I can't figure out why. And I think it proves how much we like constitutionalizing. So if that's where we are, fine. But please don't complain when, if you like red, blue gets control, and there's a few more. I just don't understand how you can complain. If you're willing to take the trade, let's do the trade, and let's get the court out of the business of running our lives. Or if we love the court running our lives, don't gripe when they don't run it exactly the right way. That one I don't quite get. My other theory as to why most people won't take the trade, and I love this, it's fundamentally American. We just always think we're going to win. We just always think, yeah, we'll get them. I know it's not going well right now. It's the 3rd quarter, but there is the 4th quarter, and we will get them. We will get them. But just remember, the other side thinks the same way. and they're also Americans. Americans love to win. So, I don't know, that's where we're in. Nobody wants to take that trade, so we're getting what we want. Big, holy battles about who's on the U.S. Supreme Court.
And on that note, please join me in thanking Judge Sutton and our panelists. Thank you again for coming, and again, we'll have a reception starting now in the Rotunda.